Hello, everybody, and welcome to the third episode of our third Tuesday webinar. Today, we are going to be covering the 10 most common mistakes in employee handbooks and how to address them. As I've reviewed several, many different employee handbooks, there are quite a few areas I could have focused on. I tried to keep it to the most common and most sort of problematic issues that we see. So while there could be more, I wanted to really focus in on the 10 most common and the 10 most problematic issues that we find in employee handbooks. My name is Janelle Stanton. I'm the Director of Communications here. And these presentations, like I said, we do the third Tuesday of each month. And I'm happy to be here again for the third month in a row doing the presentation. A couple of housekeeping items before we get to the agenda and kind of an overview here. We are going to be recording the presentation, and we will send out the recording of it. I'll also send out the handbook slides, just in case anybody wants to utilize the slides that I put together to go with the presentation. After the presentation, those who have attended the first few presentations of ours, we will be sending out the HRCI credit code. So those of you that must comply with continuing education credits, we will be providing that code after the presentation today. I will also put together Q&A, so questions that come in during or after the presentation. I will keep track of those and get written answers out to everybody in attendance, so that if you miss any of the questions that are asked or the answers that are given, if you have to jump off at the end, I'll make sure that you get a copy of those. Along those same lines, in the webinar window, there is a questions box there for you to be able to pose your questions. I will handle those as I go through the presentation. So if there are questions that are sort of pertinent to what we're discussing, I'll address them right away. If it's something that's maybe not as pertinent to the particular slide, I may hold off on that until the end of the presentation. So just so you know, you do have the ability to ask questions. We also will be sending out a brief survey, and we ask that you please consider taking a few moments and filling this out. It obviously lets us know how we're doing, how we could improve, and then topics that you would be interested in us presenting on. So last month, we did a presentation on exempt versus non-exempt employees, and the topic came directly from a few pieces of feedback that I had received. Again, this month with the employee handbook issues, that I got a few pieces of feedback on that as well. So now we are presenting on that. So next month, we're going to be focusing the content of our webinar on a business-related issue. So if you have a business-related topic that you would like us to present on, please let us know in that survey so that we can consider that for putting together the topic for our third Tuesday webinar next month. And then last, we are also going to be sending out, we have a reviewing employee handbooks checklist that is meant to walk you through best practices in reviewing an employee handbook. I'm going to be sending that out in the email. It'll either come out this afternoon or tomorrow with all of the other information. So just a heads up that we also will be providing you with that checklist. So as for the agenda, I'm going to first talk about the importance of employee handbooks, talk about the requirement or best practice that they be updated periodically, and then we'll jump into our 10 most common handbook problems and my suggestions for correcting those. So first, if you have been with us for any length of time, you'll know that we are always harping on getting an employee handbook. It might seem very obvious, but we talk to a lot of companies that either don't have employee handbooks at all, or their handbook looks like something that was typed on a typewriter in 1984, and it hasn't changed since then. This is more common than you might otherwise think, but employee handbooks are crucially important, and one of the biggest reasons for that is the federal government has really focused on deregulation. And so what that means is they're not passing the regulations that they used to pass related to HR and employment law. So to pick up the mantle, state legislatures and municipalities have created this cookie cutter patchwork of laws that mean an employee handbook that's just, maybe something that is pulled from Google or pulled online or DIY. Those types of cookie cutter handbooks, those are not realistic options for employers anymore. They're just not going to address the litany of state and city laws that are out there. And so it's crucially important that employee handbooks be created, reviewed, and implemented across the board. So a few things, obviously, an employee handbook, it's going to introduce your employees to your culture, mission, and values. Now, a lot of that is going to get done through training and mentoring, but it really introduces the new employees to your corporate culture and how they'll fit in. It's going to help foster a sense of pride and belonging, and there's been a number of studies lately that I've reviewed that show, that type of pride and belonging in a company helps employees become more productive in a shorter period of time. So while it might seem kind of hokey to be talking about your mission and culture and employee handbook, it actually is a great idea. And these would be things like, what do we do that sets us apart? How did the company get here? What are we passionate about? So that type of introduction is going to really set the standard for the employment relationship in general, but also provide that guidepost for the remaining policies that you communicate in the handbook. So like I said, seems kind of hokey, but it's actually super important that you think about what the culture is, what your mission is, and portray that in the handbook. The second point here, it's communicating to employees what is expected of them. A well-written handbook is going to give employees a clear understanding of their responsibilities. It's going to serve sort of as a compass for the organization's policies and procedures. So, it will, for example, set out the procedures for requesting time off or vacation, which is crucially important for a number of other laws. For example, having a very clear call-in procedure that's prescribed in your handbook might ward off FMLA, intermittent FMLA issues in the future. So it's really all the provisions of your handbook are going to be sort of interdependent on each other, but setting out what those procedures are, what the policies are, how to contact, for an unscheduled absence, for example. And it's also going to talk about, other responsibilities like safety, timekeeping, reporting, all of those types of, expectations that you're going to have of your employees. Obviously, it's also going to be educating your company about the company policies. So, objectives, leadership styles, if that's something that, is important to you to include in your handbook. It's going to provide information about the various entitlements to federal and state leaves, which of course vary amongst all of the states widely. It's meant to communicate those policies to eliminate confusion and then inconsistency. So if there's one standard policy regarding attendance, for example, having that policy communicated to all your employees in the same way will make sure that you are enforcing your policies consistently. The other really big component of an employee handbook is to inform employees how to report harassment and other issues like the need for an ADA accommodation or the need for FMLA leave or sexual assault or domestic violence leave. So this is huge because there may not be other places that lay out specifically who should be contacted if an employee experiences sexual harassment. And with the culture and all the issues that we've been having and seeing within companies related to sexual harassment, having a very clear, if you have a complaint about an employee, take it to your manager. If it involves your manager, take it to the HR manager. If you don't receive adequate response in 5 days, take it to the president. Having that line in the sand about who should be contacted when and how that gets reported is going to be really important for your employees so they know where to go when those issues come up and feel free to report that. And then, of course, it's going to protect your company. It's unfortunately, employers should really consider it a matter of when and not if they'll face a lawsuit or similar challenge from a current or former employee, because it's been very common for maybe not even litigation, but it's very easy for a disgruntled employee to go to the EEOC or a state equivalent of that to raise a challenge and think that maybe they were terminated under your absenteeism policy, but they're interpreting that as discrimination based on race or religion, for example. Well, if you've got a very clear policy document about absenteeism and that you require good attendance in order to meet the essential functions of your job, if that's in your policy, then the company is going to have a lot easier time showing that you had a legitimate non-discriminatory reason for the termination. Whereas if you don't have a handbook at all, or you don't have any other written policy to rely on, it can become much more difficult to try to ward off any type of litigation or agency action. So having a thorough, compliant employee handbook will help show that your company exercised reasonable care towards its employees. And their signed acknowledgement page shows that the employee had the opportunity to familiarize themselves with those policies. So you can kind of see that it's just kind of an all-around layer of protection for the company to have this handbook in place. All right, now jumping into updating. So if you're not quite sure the effective date on that employee handbook, if you have something that was typed on a typewriter, if you have no idea where it is and whether new employees hired in the last 3 years have even seen a copy of it, you've got to get that updated. We highly recommend that companies do a review of an employee handbook annually, if not twice annually. And here's why. What's happening, I guess what used to happen more frequently was laws were passed and then they had effective dates that were either January 1st or July 1st. Now that's not consistent across the board, but that used to be more typical. But like I said in the beginning slide, because the federal government hasn't been passing as many HR employment-related laws lately, the states have been sort of fast and furious working on passing a lot of very employee-friendly policies and statutes. And so what happens is you end up with weird effective dates. As an example, Michigan. And if you're in Michigan, I hope you've been following along with the ride here, but there's a new version of what was originally passed as paid sick leave, which is now paid medical leave. It was signed into law last fall with an original effective date of, I think, March 28th or 29th. Well, then what happened was industry groups, company, Chamber of Commerce got involved and felt that the statute was too employee friendly. And so a modified version of the Michigan paid medical leave law goes into effect April 1st. So you've got laws that are coming down that are effective any time throughout the year. And so it's not something that you're keeping your ears to the ground on, you could very easily miss an April 1st effective date if you're just reviewing annually in January and July, for example. So it's not been they have not made it very easy on companies to make sure that you're complying with all of these various laws. So that's why we recommend at least twice a year, if not more, taking a look at those employee handbooks. So, all right. So jumping into the common errors, and the first one is something that, again, we here at myHRcounsel have seen many, many times. A handbook that's pulled from Google or some other public university or a company that's used a DIY template. I've actually seen a handbook that had references to Google's corporate office. So they pulled the Google handbook, made changes, but didn't get all of the references to Google pulled out of there. And so while it can seem tempting to use a handbook that was created by a big company like that, or by, an upstanding, presumably compliant organization like a university, or seem like a steal of a deal to use a free or cheap DIY handbook builder, every company is different. If you pull a public university employee handbook, they receive federal government funding. So many of the handbook provisions that apply to a public university are probably not going to apply in any way to a privately owned company. We have seen clients pull handbooks that are online from an airline. Airlines are subject to a lot of federal regulations and rules, and they were a small, less than 50-person retail establishment. And there was actually FAA regulations, references to executive orders, and unions in their handbook that did not apply to their workforce in any way. So because companies are so different, pulling off a template or grabbing a DIY handbook builder, while it might allow you to plop your mission in there, what if you're in a state like California or New Jersey with many state-specific laws that the company has to comply with? Is that template just providing you with federal law oversight? There's cities that are getting in the game now. So you have to know what state-specific, city-specific laws you have to comply with, make sure that they're in the handbook, and also when is the last time something like that was updated? Because I've seen templates out there, and the last time they were updated is like 2013. Many, many laws have been passed since that time. So if you don't know the last time that handbook or template was updated, again, that could be very problematic if you're just going to pull that and try to use it. The resolution is obviously apparent and very self-serving, but to avoid the costs and headaches down the road, just having an attorney draft you a state-specific, legally compliant, updated handbook is going to go a long way to ensuring that what you have, what you're providing to your employees is compliant. We have clients that are in 40-plus states, and so we have drafted employee handbooks that have a state addenda for 20 different state laws, and then sort of a main handbook that kind of covers most of the states that don't have that many unique statutes in them. So we have experience in drafting those. It's a process. Any of our clients that are on the line that have gone through it with us can attest to that. But it is something that we highly recommend you have an attorney draft for you. Common error number 2. So the second error that I notice a lot of times is that employee handbooks are missing the state-specific protected classes. Now, a protected class, of course, is a class of person that has special protections under the law. So Title VII, for example, prohibits discrimination on the basis of race, color, in those types of protected classes. The Age Discrimination Enforcement Act prohibits discrimination on the basis of age. So a protected class is a person who is protected by some form of law. And basically everybody is in a protected class. I've had some people tell me that white men are not in a protected class, but that's false because white is a color or race and men is a gender. So everybody is in some form of protected class. So it's a misnomer to say that they're not. But when you're spelling out in your employee handbook, for example, in your anti-harassment policy or your, let's get to the next slide here, your EEO statement, you want to make sure that you are covering all of those classes that are prohibited from discrimination in your state. And the reason that that's important is you want to be able to notify your employees of what classes of individuals are protected in your particular state. So while federal is race, color, national origin, religion, sex, disability, age, citizenship, and genetic information, many of the states have some more interesting or varied protected classes. For example, Florida has a protected class is sickle cell trait. So individuals who have sickle cell trait are a protected class in the state of Florida. New Jersey has similar to sickle cell trait, but New Jersey calls it atypical hereditary cellular or blood trait. That's a protected class in New Jersey. In New York, you are in a protected class if you observe the Sabbath, or lawful use of any product or lawful recreational activity when not at work. So this is the lawful consumable products law, which basically means that because it's legal to consume alcohol or legal to consume cigarettes, if you do that outside of work in a recreational capacity, you cannot be discriminated against for that. Iowa, it's a protected class if you've suffered from wage discrimination. Many states have updated theirs to include AIDS, HIV. So somebody who has AIDS or HIV would be considered to be in a protected class. So just be mindful that there's different states have varied protected classes, and those should be spelled out specifically in that EEO and anti-discrimination harassment policy. So just another common error that we see a lot. And a note of something to be mindful for. Many laws, so even if, for example, you're a Florida employer where sickle cell trait is a protected class, keep in mind that even if that is the case, that law may still not apply to your company depending on size. So, for example, the Americans with Disabilities Act applies only to companies with 15 or more employees. So a lot of companies might think, we're off the hook, we do not have to comply and can hypothetically discriminate against disabled individuals. I would never recommend that, obviously, but hypothetically there could be companies that the Americans with Disabilities Act does not apply to. But you might have state laws that expand the scope of that. So the Minnesota Department of Human Rights Act, for example, covers employers with one or more employees. So since the Department of Human Rights Act in Minnesota prohibits discrimination on the basis of disability, basically a law that's very similar to the ADA applies to all Minnesota companies with one or more employees. So just a heads up there. that it may not apply to you based on size, but there could also be state law differences within those laws. Common error number 3, throwing in everything, including the kitchen sink. I just yesterday reviewed a 133-page employee handbook. And those of you who are in HR or familiar with HR know that it's the rare employee who is going to read 133 pages of HR policies and procedures. Trying to anticipate every single issue that may ever come up is not what the employee handbook is for. It can seem tempting to try to cover it all, but you actually could end up getting your company into way more trouble that way. What I've seen with some of these very long handbooks is a company is actually, instead of just making it about the employee, they're actually trying to use it for operational standards for HR to comply with. So I've seen employee handbooks that are kind of a how-to on conducting investigations, or policies about how pay levels are set, procedures for hiring an employee. Why would you put procedures for hiring an employee in an employee handbook that you're going to give to employees? They're no longer applicants. So having something like that in the employee handbook doesn't make sense. And so the employee handbook needs to be concise. It needs to be tailored to what it is that they need to know, and it's not for your HR department. We've drafted these before. Keep that type of information in like a procedural policy or HR manual that is specific to your HR folks. Another caveat with this, because it might just seem, it may seem obvious to you at this point to have that separate, but I do want to point out we've had seen in the past where an agency like the Department of Labor comes in to do an investigation of a company and they ask to see the employee handbook. If the employee handbook includes everything that an HR manager needs to know, and there's some procedure in there that is illegal or problematic, you may have just made the case for the Department of Labor to find that you have done something illegal with regard to your employees. So keep that stuff out of the employee handbook. Keep it in a procedural manual, HR manual, and just keep the handbook concise. Our handbooks are about 40 pages long. Still a lot of material, but just for reference, ours are about 40 pages. All right, common issue number 4, forgetting that the National Labor Relations Act applies to your company even if you don't have unions. So the National Labor Relations Act, most of that act applies to companies that have unionized. But the National Labor Relations Act, the NLRA, has what's called Section 7, and it's been a major headache for companies for a while. The pendulum is swinging back in the favor of companies, but Section 7 rights, for those that are not familiar, are rights that protect an employee's ability to participate in what's called concerted activity. So meaning that they're working with or communicating with other employees to help improve the terms and conditions of their work. So that's Section 7 rights. And this had gone very, very, very employee friendly. A memo was recently issued in late 2018 to sort of scale some of that back. But there are still several components of the NLRA that apply to companies that don't have unions. So one thing, this is the most common one that I've seen, is rules requiring that employees keep confidential their wages, benefits, or other working conditions. So I've seen things like, employees are prohibited from disclosing salaries or contents of employment contracts. I've seen things that say employees shall not disclose any information pertaining to the wages, commissions, performance, or identity of employees of the employer. That all needs to be removed from employee handbooks. You cannot prohibit an employee from discussing the wages or benefits with other employees. That is protected by those Section 7 rights that I was talking about. You should also remove any rules against joining outside organizations. Obviously, companies have a legitimate interest in preventing nepotism, fraud, self-dealing, that sort of thing, but rules that specifically prohibit membership in outside organizations infringe on Section 7 rights. And essentially, the National Labor Relations Board is trying to prohibit employers from discouraging union formation, but I've seen rules against joining outside organizations just in general in employee handbooks. Now, you could have a rule against joining outside organizations where there's a conflict of interest with your company, but you're going to need to specify that. You should also consider, if not removal, modification of rules against disparagement of the employer. An employee is free to disparage the employer as long as they're not making defamatory or basically lying about the company. That action is protected by Section 7. Remove rules restricting speaking to the media. That can be tailored to not speak to the media about trade secrets or other confidences of the employer, but just a broad rule restricting speaking to the media is going to violate Section 7. Similar to rules against making false or inaccurate statements. So it's really got to be limited to rules against making defamatory statements against a company. So I know these things seem crazy, but they are violations of Section 7 of the National Labor Relations Act. The consider removal bullets, you can have a version of that in there, but you have to be careful with how it's worded so that it's narrowly tailored to protect the trade secrets or business interests of the employer. So the top ones, absolutely remove. The bottom ones, make sure they're narrowly tailored. All right, common error number 5, forgetting to include an at-will employee disclaimer. I say this a lot, I feel like, but employment contracts really should have gone the way of the dodo a long time ago. But believe it or not, I do still counsel clients on how to get rid of a poorly performing employee who has been given a contract of employment with a guaranteed term of employment. People are still using these, and we never, even for the highest level executives, we do not recommend employment contracts. If you are going to utilize an employment contract, you should definitely make sure that an attorney drafts that for you so that you can adequately define good cause. But the last thing you want to worry about is trying to get rid of a poorly performing employee, but worrying you're going to get sued for breaching that contract. So all employee handbooks should include a disclaimer that nothing in the handbook creates a contract for employment or alters the employee's at-will employment relationship. It's super important. At-will employment, just as a quick refresher, means that an employer can terminate an employee at any time for any reason without notice, as long as it's not for an illegal purpose like discrimination or retaliation. So likewise, an employee can leave their employment at any time without providing notice. So making sure you're not altering that at-will employment relationship with the employee handbook is very, very important. And while I'm at it, I'm going to tell you that I also recommend companies take out that 90-day probationary period. Again, I see lots of handbooks that have a 90-day probationary period where it's, we'll see how you fit, we'll see how you do. If after 90 days it's not working out, we're going to let you go. If after 90 days it's working out, great, you're no longer on probation. You don't need that. The employee is an at-will employee anyway. So you have the ability to, you can discharge an employee if they're not working out after 1 week. Why make them sit around for 90 days figuring out if it doesn't work? We have seen some cases where courts have held a 90-day probationary period to actually be a guarantee of employment for at least 90 days. So take that out of there. You have at-will employment, which is going to allow you to terminate them at any time that it's not working out anyway. So just getting on my soapbox a little bit about the 90-day probationary period, but having the at-will employment statement in the handbook, very, very important. All right, common error number 6. So thinking that your short and sweet, very simple anti-harassment policy is good enough. This is one area that I harp on a lot because with the climate these days, there really is no policy that is more important than an effective anti-harassment policy. This is not the area to scrimp on space. So as far as the anti-harassment policy, make sure that it's very clear on what harassment is and what it's not. So have a definition of what harassment is. It should state that harassment can be visual, verbal, and non-visual. It should have examples for example, verbal, making comments, catcalls, whistles, things like that. Having examples of what is harassment that go with the definition. Describing the procedure that an employee has to follow to report an incident of harassment. So I talked about this in the beginning, but including the specific person to whom an employee should report the harassment, and then an alternate person if that first designated person is the alleged harasser. So that's having that reporting procedure, having even phone numbers or the current person who occupies that role. So if you say report it to the president, maybe put the current president's name in there, remembering to update that if that changes, so that your employees know who the president is should they need to escalate their complaint higher than somebody in HR, for example. You can also include a form for employees to complete to report workplace harassment. It's not necessary, of course, because reports, you should allow employees to make reports in written format and oral format, but maybe having a form that's detailed to say what happened, who is the alleged perpetrator, were there any other witnesses involved, so that you can try to gather as much information as possible for your upcoming investigation. Having a form like that might be helpful, and let employees know that you will promptly investigate any complaint, even if it's not submitted in writing, and that you'll take action regardless of the position that the alleged harasser occupies. So if it's the CEO, they're going to be investigated and held responsible, just like the guy that's been there a week. So you need to ensure that you're creating an entire environment that is conducive to employees reporting harassment as it happens. And so laying all of that out in that policy, super important. All right, common error number 7, having a progressive discipline policy that is way too rigid. So this is kind of how these typically go. First offense, verbal warning. Second offense, written warning. Third offense, third strike, and you're out. The problem with a progressive discipline policy that's rigid like this is that an employer doesn't have flexibility necessarily to terminate as needed. So what if, as just an example, an employee's first offense is stealing from the till or cussing in the presence of a customer, and you want to write them up and maybe not terminate, but this is their first offense, so technically your policy requires a verbal warning. What if it's actually an employee's third offense for absenteeism, but you haven't fully considered whether FMLA applies? The moral of the story here is employers need to have flexibility to terminate on the first offense and not terminate on the third offense. So with that, your policies should state something like, disciplinary policies that you reserve the right to skip one or more steps as necessary, and that the company, in its discretion, may discipline an employee with verbal coaching, a verbal warning, a written warning, more training, a performance improvement plan, or termination, sort of all of the various options that you might consider for disciplining an employee. You'll want to make sure that you've got a list, and that whether it's the first offense or the third offense, the company retains the right to be able to discipline however they see fit. It's also a good idea to have a list of actions that would warrant discipline. And, from theft to fighting to, absenteeism, insubordination, all of the different sort of offenses that an employee could commit, but state that list is illustrative only and not meant to include every infraction for which they could be disciplined. So give an idea to your employees of the various types of things they could be disciplined for. All right, common error number 8. So you've got a perfectly coiffed new employee handbook. It's beautiful and sparkling and great. It's got everything in it that you need, but you didn't get all your people to sign off on it. This happens a lot. If you are trying to chase down remote employees, or an employee says, yeah, I'll get it to you, but you don't have a tracking mechanism and somebody falls through the cracks. So I've got a scenario for you. This came from an actual case. Names have been changed for anonymity. Jane sexually harasses John. You, as the HR manager, felt that you handled everything appropriately. You did the investigation. You, suspended Jane for unpaid leave for a week, and then you transferred her to a different division so she doesn't have to work with John anymore. You thought, this is awesome. Unfortunately, John doesn't think that's an awesome resolution, so he hires a lawyer and wants to sue your company. So you call up your friendly neighborhood employment law attorney, and that attorney says, great, I will help you, but I'm going to need to see some documentation. So I want to see your sexual harassment policy, and I want to see Jane's acknowledgement of receiving it. So you dig through the personnel file, and you come up empty-handed. There is no acknowledgement. So now your attorney has to find a way to an alternative method for proving that Jane knew that sexual harassment was considered, what was considered sexual harassment, that it was inappropriate in the workplace, and we don't have any way to say that Jane knew that. Now, common sense dictates, you shouldn't sexually harass your coworkers, but without having that, the best policies in the world, you can't prove then that your employees had received that. So again, it might seem very commonplace idea that, of course you need to have an acknowledgement page. But many times this is something that gets missed, and it's simply based on an issue with tracking. And so what we recommend is that you find a way to maintain a system to track who has received the updated handbook and whether you've gotten that signed acknowledgement of the handbook. And just continue tracking down, hound down those employees that don't get those acknowledgements back to you, because those, like I said, are very important should litigation or some type of complaint come out of an action that one of your employees engages in. So having the handbook policy and then saying, see, Jane received this sexual harassment policy. She knew what she should have known, that what she did was sexual harassment. We then investigated. We disciplined her. There is no suit here for John. So having that system to track that is very important, and it can be done electronically. There's HR systems out there that have electronic signatures that really do simplify getting employee acknowledgements. They can read all the policies in digital format and then, signify their understanding and agreement to abide by them electronically. So if you have something like that, getting those signatures electronically is acceptable and can eliminate a lot of the issues of trying to track down those problem employees. All right, number 9, forgetting that some types of leave policies like FMLA are required to be in the handbook. So in addition to posting an FMLA poster in a conspicuous place in your office, the law actually does require that you mention it in your employee handbook if you distribute an employee handbook. So if your company does an employee handbook and you are obligated to comply with FMLA, you have to include a section about FMLA in your employee handbook. That must be there. And a lot of times it's not. There's also other types of leave that should be in an employee handbook. So the way to resolve this is obviously to know the leave laws that apply to your company and make sure they're included. There are some of these laws, some of these leave laws, for example, that require notice to be either displayed, like in a break room or lunchroom, or in an employee handbook. So in that situation, you have the option to display it or put it in an employee handbook. But if you have, for example, a lot of remote workers or employees that just don't come into the office very often, putting that notice in the handbook is probably going to be the best way to communicate those types of leaves. For example, New York State has a law that requires employees be notified of their right for breastfeeding break time, so break time to breastfeed. So that can be provided either through a general notice to all employees, so putting that in the break room, or by having it be put in the employee handbook. So that law, for example, gives you the option. New Jersey doesn't give you an option with regards to New Jersey Family Leave Act. If a company provides an employee handbook, then the handbook must contain a notice of the New Jersey Family Leave Act. So there's lots of various ways that you can comply with this, but the moral of the story is make sure you know what laws apply to you and which ones are required to be in your handbook. Also, many of the different types of leave, it's a best practice to have in your handbook. So I usually always recommend that jury duty leave, military leave, voting leave, bereavement leave. I always recommend that those types of leave be included, but things like bone marrow leave or civil air patrol service leave, some of those things are so vague and so rare that it's not necessary to technically have that in there. But some of the leave that isn't required, I still recommend having. And side note, make sure that your if you do use payroll HCM software, that they're properly tracking the law's requirements. A few times I've had clients come to me and they say that we are required to comply with 4 different cities in California, and they all have different paid sick leave requirements, and this isn't tracking accurately. So this is a side note. Do make sure that you know that it is tracking properly. We've seen some issues with that in the past. So using a reputable HCM software is very helpful to keep track of all of the crazy leave laws that are out there. Got a question here. Do you have to include FMLA in the handbook or displayed if you don't have 50 employees? No, you do not. So you have to be governed by FMLA in order to be able to, or in order to be required to have to post that. So this question got, oh, here we go. Question regarding tracking. Do you think it's necessary to have temporary employees from a third-party agency sign off on acknowledgement of handbooks? No, and you will want to make sure that if you are using temporary employees from a staffing agency, that those temp employees are governed by the staffing agency's policies. Those employees should not be subject at all to your employee handbook, your employee policies. None of that really should apply to those temporary employees. So no, temporary employees should not sign off acknowledgement of your handbook. All right, that's all I've got for now for questions, but feel free to keep sending them in. And common error number 10. So not stating what happens to accrued but unused PTO or vacation in your handbook. So I've seen a lot of PTO or vacation policies that do not include a statement about what happens to vacation or PTO when an employee terminates, either through voluntary or involuntary separation. The reason that this is critically important is because many states, their statute says that it is based on the employer's stated policy as to whether accrued but unused vacation or PTO gets paid out. Now, some states, you don't have a choice. California, sorry. If the employee has accrued but unused PTO or vacation when they terminate, it has to be paid out. But the bulk of the states out there state that whether or not it gets paid out is contingent on the employer's policy. And usually the only place where an employer's PTO or vacation policy is housed is in the employee handbook. So you'll want to make sure that your handbook states whether or not you are going to pay that out. And no, you have to also know, of course, if your state requires it. If your state requires it, it doesn't really matter. But if you're a state that says it's contingent on what the employer's policy says, make sure that you have a statement about, yes, it gets paid out, no, it does not get paid out. If your handbook is silent in one of those states where it's based on the employer policy, I have seen this before where a departing employee may have a claim that you're required to pay out the accrued but unused PTO time based on what's called an implied promise. And so, or promissory estoppel is the technical name of it, but stating that, you know, they were receiving the vacation time, they had accrued unused time when they left, you didn't pay it out, and because the handbook was silent about what the policy is, it's implied that it was meant to be paid out. You don't want to be in that situation if you don't want to be paying it out. So make sure that you know the payout law of your states where you have employees, and make sure you include that statement in the employee handbook. All right, so that is kind of the end of the plan material that I have here. Let me see what other questions I've got. Just is a question about salaried employees. So it says, what has to occur to not pay a salaried employee a full week's pay? And so this is a question about a sick time policy. You know, can it be worded so that if a salaried employee has used their sick time, that will not be paid for the remainder of the week? So I think this is kind of like an exempt, non-exempt employee question. But so if you have an employee that is exempt, not salary, but exempt, they have to be paid for any day in which they perform work. So if an employee who is exempt misses a full day, they don't necessarily, you could dock their pay for that full day. But if they do any work in a particular day, then they must be paid for that full day. All right, let me just see. Yes. The question is, can you provide a copy of the webinar and any documentation that was used with this presentation? Yes, I will be sending that out to all of the attendees. The last question is saying that in Florida, I believe you have to notify an employee of the 90-day probation to be able to let them go to prevent them from getting unemployment. I'll have to research Florida law and confirm that for you. I will, you'll find the answer to that question in the Q&A. Oh, this is a great question. Is it a big deal if an employee signs off on the handbook on day 1 versus 1 week later, or as long as you have the signature, that is the important part? Great question. So if you have the signature on the acknowledgement page, what the acknowledgement that we send out anyway says is that the employee is saying and signing off to the fact that they have read and understand and agree to comply with all of the provisions of the employee handbook. So if they're signing off saying, yes, I did read it, I understand it, I'm going to abide by it, that is enough. Now, hopefully you're giving your employees, your new hires, some time to actually be able to review it, but it's not a requirement that you like give them a quiz or give them X amount of time. As long as you have their signature on the acknowledgement page, you then are able to say that the employee should have read it and known what was included there. What about an employee trashing the company on social media? I'm assuming this is a question related to the National Labor Relations Act. So it depends on what you mean by trashing the company, because there are certain actions that are going to be protected by the National Labor Relations Act. And so where, if the employee, their version of bashing the company is, hey, I don't think my company is paying me well. My benefits, if it's about their benefits or working conditions, and the whole point of it is to start a discussion about wages and benefits and improving the life of your fellow employees at work, that is protected activity. Now, they can't be out there saying, hey, this company does, these horrible illegal things, and that's a lie. That would be defamation, of course. If they're saying, hey, this company, they're looking to open up a branch in Mexico, and I don't agree with that because they're going to be outsourcing all of our jobs, and that's a trade secret or some type of confidential information. That is not appropriate. So it just depends on the contents of what that employee would be saying on social media. A great question. And I did have a message from somebody saying that the audio was cutting in and out. I hope nobody else was experiencing that issue, but for that individual, this is recorded, and I will be sending out the recording. So if there's any pieces of what I was saying that you missed, that would all be in the recording for you. So I apologize for that. I didn't get any other comments that there was issues with the audio, so I hope everything came through okay for everybody. All right. That takes us up to noon. I do want to be mindful of everybody's time. Thank you so much for joining us again for our third Tuesday webinar. Please remember that you can contact us at info@myHRcounsel.com or on our website, myHRcounselcompliance.com, if you have any questions about employee handbooks or you would like to get set up with our service. Please let us know. I'd be happy to talk to you about what our plans are like and what our offerings are. So I hope everybody has a great day. And please don't forget, if there is a business-related topic that you're just dying to know about, in the survey, let me know so that we can make sure we're presenting on topics that everybody finds useful. So have a great day, everybody. Thanks for joining us again.